answers to them. But I respect your duties as a sitting judge and your responsibilities as a nominee to our nation's highest court when you say that you don't want to impinge upon your right to sit on some of these very important issues as they come up in the future. Nor do you want your right to sit on those issues and to hear those issues questioned. And that they could be questioned if you got into your particular points of view at this time, assuming you have them. So I suggest you just keep answering the questions in the very responsible manner that you have been answering them. That's the way any good judge would answer these questions, in my opinion. Now, Judge, the court on which you sit, the Circuit Court of Appeals for the District of Columbia, handles quite a few cases of statutory construction. Is that correct?
That's correct, Senator.
Now, you've sat on approximately, as I understand it, 170 judging panels. Am I right?
I think 150 or so cases.
Okay, but more than 150 cases. And let me just ask you this question. In your decision, have you resorted to legislative history in construing these statutes?
Senator, as I have indicated, when the statute is ambiguous and in an effort to discern the intent of Congress, there have been instances in any number of cases when either myself or another judge with whom I sat, an opinion in which I signed on to, referred to and included legislative history. It's where relevant, it's an important part of our interpretation of statutes from this body and from in other areas.
Well, in your decisions, have you relied upon natural law?
No, Senator. As I indicated earlier in my prior discussions with the chairman, I indicated that in adjudicating cases, the limited role of natural law with respect to our framers, but beyond that, the references to the history and tradition of our country.
Well, I think that's an important distinction. Now, when a senator asks you as a nominee, do you believe the Constitution protects a woman's right to choose to terminate her pregnancy? I personally believe the nominee is being asked to decide the principal underlying issue in those types of cases, or certainly in a number of cases that are expected to come before the court, and probably in the immediate future. Now, it's irrelevant, in my opinion, and I think in most fair observers' opinion, that if the senator adds, oh, but don't tell me how you're going to decide a particular case. Once you give the answer to the first question, does the Constitution protect a woman's right to choose to terminate her pregnancy? If you give the answer to that question, whichever that answer may be, you're well on your way to deciding most of the particular cases in the progeny of cases since Roe versus Wade. Now, let's not kid ourselves. We all know that. And it is, in my view, inappropriate to keep this up. Thus far, you have been asked almost, or a little bit more than, 70 questions on abortion. Now, I don't know why you're being singled out, because Justice Souter was asked 36 questions on abortion. And that was way too many, since he hadn't decided how he was going to go either. Now, as I heard your testimony the day before, you said that you're basically undecided on that issue, if I understood you correctly, and that you are reserving your judgment till the time when you can listen to all the facts and all the issues and all the case law and all of the other materials pertaining to that particular issue. Am I wrong in stating it that way?
Senator, I indicated that I think it's important that I retain an open mind and that I don't have an opinion on that important case.
Well, if you answered that question that I cited at the beginning, which is probably the pivotal question, there may be others, but certainly I'm making this particular point, I think you would call into doubt whether or not you would be impartial in cases that may be in front of you in the next year or so. And I would just add that I do not recall you replying to questions Tuesday or yesterday with the specificity that you've been pressed with these abortion questions. 1 year ago this week, Judge Souter declined to say anything about abortion. He was approved 13-1 in this committee. 13-1. And he refused to say anything about it. I think the burden is on those who would condition your confirmation on answering questions about abortion to tell the American people why you're being treated any differently from Judge Souter. 70-plus questions so far versus 36. And I think when you say you are going to keep an open mind, you are undecided, you are going to look at everything, and you are going to do it in the best way you can, make a decision with the best honest way you can, I think we ought to take your word for that. Especially since you have a reputation for integrity and honesty, and I don't think anybody questions that. So I question why you're being treated differently from all of these confirmable people in the past. Now, I know it cannot be that throwaway line in a 9-page single-spaced speech to the Heritage Foundation. I don't think it should be judged by that. I think it should be judged by your testimony here. I think that reads so thin that it's invisible. But so much for that. I just have to say that you've been asked double the questions of Judge Souter. Now, what are we going to have, 64,000 questions on abortion before we're done with this approach? I mean, you'd think from listening to what's going on here that that's the only issue the Supreme Court has to decide. I have to say, I think it's a tremendous mistake, condition of confirmation of a Supreme Court nominee on any single issue. I have to admit, I feel very deeply about that subject, too. And I wouldn't mind knowing if you knew how you would rule in advance myself. But I'm not going to ask you, because it is a controversial issue. It is a difficult issue. It is one you're going to have to hear. It is one where if you gave your opinions now, I think you would seriously erode any confidence you would have when you are on the bench trying to make the final decision on any number of cases that might come before you. So I think, there's a time when enough is enough. And frankly, I think you've more than adequately said you will do the very best you can to honestly decide those issues based upon the materials that are brought before you when you are sitting on that court. And that as of the present moment, you haven't an agenda and you haven't made up your mind how you will vote on those issues. And how could you? Because nobody knows what those facts are going to be. Nobody knows what the particular case is going to be, except some of those that may be pending at the present time. Well, enough on that. The subject of affirmative action came up yesterday and today, I have to say. Now, I have some questions on that, but let me just make a few comments first. Affirmative action can mean different things. It can mean reviewing one's employment practices to eliminate discriminatory practices. It can mean increasing an employer's outreach and recruitment activities aimed at increasing the numbers of minorities and women in the applicant pool, from which all applicants will then be considered fairly, without regard to race or gender. There are similar activities aimed at widening the pool of applicants, and I'm going to ask about those. This form of affirmative action has widespread support in this country for it. You've spoken, and you've written about it, and you've written for it, and I am not aware of any single member of the United States Senate who opposes that position. Now, I believe that discrimination against anyone should be ended, and it should be remedied. And there is still much discrimination against minorities and women, and I think we should do everything we can to root that out in this society. And I favor the kind of affirmative action that I have just described, which you have described. But there's another form of affirmative action which is highly controversial, deeply divisive, and I have to say wrong. By whatever euphemism or label used to describe or mask it, this form of affirmative action calls for preferences on the basis of race, ethnicity, and gender. Lesser qualified persons are preferred over better qualified persons in jobs, educational admissions, and contract awards on the basis of race, ethnicity, and gender. Some argue that there's a distinction between a quota and so-called goal and timetable. But that, in my view, is misleading, and it's of no practical meaning. It isn't the label that is objectionable, but the practice. And the practice is unfair preference given to one American citizen over another. It doesn't matter what one labels a numerical requirement that requires causes or induces preference. If you're discriminated against because of it, the harm is all the same, regardless of the, quote, feel-good, unquote, label someone else might happen to put upon it. And the harm to the victim is the same if the employer is private or public. Yesterday and today, reference was made to the Johnson case. This is a 1987 Supreme Court decision. All 238 positions in one job were held by males at this particular employer's business. And this is an important point, this next point. There was no finding in the case of discrimination against the employer, notwithstanding the out-of-context quotes that we heard today. No finding. So the appellate court could not look that there was a finding. Under a non-discrimination standard, Mr. Johnson would have been selected. Among the 7 qualified persons, he was recommended for the job and did have a slightly higher rating than the woman who was ultimately selected. What happened next is that the County Affirmative Action Office got involved, and the County Affirmative Action Coordinator recommended to the hiring official that the woman be hired. Now, he did hire her, taking into account qualifications and, quote, affirmative action matters, unquote. Now, promoters of preferences, they like to say, well, the person preferred was qualified. But if a better qualified person, even if only so slightly better qualified, loses a job because race or gender counts against him or her, I have to say it's unfair, and I think that's what basically you have said. This preference was taken under a plan that I believe one of my colleagues yesterday described as not a quota, but an affirmative action plan. But I stress the label. Whether it's called a quota or affirmative action plan or anything, that's not the key. It is the practice of preference based on race, gender, and other irrelevant characteristics that is the key here. The reason to oppose a quota is because it causes preferences, not because the word quota sounds bad. So it is not enough to say we oppose quotas. We must oppose preferences. And we have to oppose the various means by which preferences are required, caused, or induced. Now, Title VII, as you know, and you're an expert on it, as enacted, bans preference. Title VII is not a heavy-handed interference with the private sector, as its opponents claimed back in 1964. It is the embodiment of the principle of equal opportunity and non-discrimination. But in a 1979 decision George Orwell could appreciate, the Weber case, the court construed Title VII to permit preferences in training. Now, there a white male was discriminated against. In the Johnson case, the court extended this creative interpretation to hiring. 5 members of the Johnson court said Weber was wrongly decided, 5 of the 9, that it had turned Title VII on its head. But 2 of them adhered to stare decisis and not only let Weber stand, they extended it. Now it is desirable to increase minorities and women in various jobs, and that's a desirable thing, and I'm for that, and you're for that, but not at the price of discriminating against other hardworking, innocent persons who are not privileged people in this country. And I have to add that there have been many instances where preferences for members of one minority group have disadvantaged members of other minority groups and women. Preferences for women have disadvantaged minority males as well as white males. In an increasingly multicultural society, the preference problem is less a black-white issue. The victims of preference do not have 150 groups out there lobbying for them, but they do have a moral right to be free of discrimination. That moral right was codified in the statute at long last in 1964 for all Americans. And I think it's that statute to which all judges ought to be faithful. The victims of preference know that however labeled or candy-coated, preferences are unfair, they are immoral, and they don't even have to be lawyers to understand it turns the statute on its head. I don't think it's divisive to defend the principle of equal opportunity for every individual. I think it's divisive to compromise that principle. If one wishes to require equal opportunity for all individuals, regardless of race, ethnicity, and gender, our laws and Constitution as written already require that. There is no need to establish a numbers requirement. A racial, ethnic, or gender numerical requirement, however labeled, is intended to be met. It is not intended merely to increase recruitment of minorities and women into the applicant pool, which can be required in its own right. It is intended to induce preferences of lesser qualified over better qualified persons in order to reach the so-called, quote, right numbers, unquote, in hiring and promotion, educational admissions, and contract awards. And that is as true in the private sector as in the public sector. Now, Judge Thomas, you criticize this kind of preferential affirmative action while in policy positions. So I want to explore just for a minute forms of affirmative action and ask your position on them while at the EEOC. These are things I agree with, and I'd kind of like your opinion to see just where you come down. Judge, let me ask you this. While you were at the EEOC, how did you feel about companies seeking referrals of applicants from organizations such as the Urban League, LULAC, the GI Forum, colleges and high schools with high minority enrollment, national organizations for women, black fraternities and sororities and similar groups? How did you feel about that?
Senator, I think that particularly in those instances in which the question is, how does a company reach minority applicants? I have felt that those avenues, among others, were very, very helpful. You can use the similar approaches in education, in which you have contact with organizations that are supportive of minority students and who can provide access with that student to the institution. I think that all of those accesses are important. Again, those are efforts to get minorities at the door of employment and to make that opportunity available to them.
But how did you feel about employers providing briefings to the groups I mentioned on the employer's premises, as well as plant tours, explanation of job openings, and so on? Do you have any problem with that?
Senator, I think those are important. Again, the idea is to get information. I think some employers go so far as to actually have programs in high school in which they mentor the students, or programs in which they actually provide summer training. We had one at EEOC in which we had interns who were hired into the agency, as well as stay-in-school programs and co-op programs, where we had an opportunity to take a look at the students and to really provide them with opportunities down the road.
I agree with that. What was your view about employers asking their minority and female employees to refer job applicants to the employer?
Again, it's a way to provide access to individuals. It works both ways. It's a two-way street. Individuals who might not have come to that employer, or on the other hand, the employer may not have known of, are provided access, and I think that's, again, as important as the other avenues that we've mentioned.
I agree with that, too. What was your view about employers actively recruiting at predominantly minority and female schools, colleges, and universities?
Similarly, Senator, it's an opportunity for an employer to find individuals at institutions that have trained them and prepared them for the workforce. As you know, I've been very supportive of efforts of that nature. There were programs that we had, again, the co-op programs that I mentioned, at predominantly minority institutions. And the idea was to actually not only help in preparing a student to become a part of the workforce, but also for us to conduct an interview over time. And we've been able to get, or were able to get, some very, very good employees out of that program.
That was one of the methods that helped you, wasn't it?
I was.
I certainly agree with it. What was your view about an employer recruiting in schools where there were fewer minorities or women, seeking out those fewer minorities or women to encourage them to apply?
Again, I think that is an important effort, and again, Senator, it provides access, it provides contact.
What was your view about employers advertising for applicants in media with a predominantly minority or female audience?
I think it's, again, Senator, when you're attempting to recruit and you're looking for employees, individuals who are minorities, you have to, again, look at the readership or distribution of the media that you choose. And I think it is important. It may not be as aggressive sometimes as I think it should be, but I think it's very, very important.
What is your view about employers establishing motivation, training, and employment programs for hardcore unemployed of all races and both genders?
I think consistent with what I've said earlier, Senator, I think we have an obligation to include those individuals who've been left out of our society, in the economy, in our schools, our educational programs, etc. I think that is an important obligation, and one that is certainly discharged in part in that way.
Did you object to employers establishing equal opportunity offices?
I support that, in fact, encourage it. I felt that those offices should actually be enhanced. They shouldn't be afterthoughts in organizations, that they would have to be a part of the employment decisions or the promotional decisions. They would have to be in the chain of command as opposed to a satellite office.
Well, so these and other affirmative action steps can be taken to enhance the opportunity to compete for jobs. But when the time comes for hiring and promotion, has it been your view that these decisions should be made without regard to race or gender?
Senator, that's been my view, and I think that at EEOC we were able to accomplish both ends. We were able to improve the number of minorities and women in the upper ranks of the agency, and at the same time make the decision based on the best qualified. It's a record that I was particularly proud of, and one that I think exemplifies the approaches that you're talking about.
Judge, could you explain your views about the adequacy of the current Title VII penalties for intentional discrimination?
Senator, let me just simply restate what I've said in the past. I think that Title VII, for the kind of injury that we're talking about, that Title VII needs to be stronger. I've said that in the past, and that's an important point. A lot is being demanded, or was demanded, of Title VII, and as chairman of EEOC, I felt that it was undervalued, that the damage to individuals was being undervalued, that there should be more damages, and that there perhaps should be stronger penalties.
Well, I agree with your comments, and I agree with your statement, and there are many ways that we can accomplish the integration of minorities, women, and others into the workforce without using preferences. And you've been a prime example of how to get that done, and your tenure at the EEOC shows that. And I want to compliment you for it. Now, some have charged you in your statements in these hearings that natural law is not an independent rule of decision in adjudication. That your statement on that is inconsistent with your earlier writings and speeches, and that this represents a confirmation conversion. Now, that's pure nonsense as I view it. First, if you did think that independent recurrence to natural law and adjudication was proper, one would expect to see some evidence of that in your decisions on the current court upon which you sit, the Court of Appeals. But what your opinions show is a careful consideration of the written law, and that's why I started off with the statutory law. Moreover, a careful review of your writings and your speeches reveals a recurring theme that natural law demands limited government, and limited government demands that judges not overstep their constitutional authority. Is that a fair comment?
Fair comment.
In the September 9, 1991 New Republic magazine, no shill for the Bush administration, reporter Jeff Rosen reviewed the judge's writings, and he concluded that they, quote, show that his views have been not only caricatured, but turned on their head. Far from being a judicial activist, Thomas has repeatedly criticized the idea that judges should strike down laws based on their personal understanding of natural rights. Far from being bizarre or unpredictable, Thomas's view of natural rights is deeply rooted in constitutional history. Like many liberals, Thomas believes in natural rights as a philosophical matter, but unlike many liberals, he does not see natural law as an independent source of rights for judges to discover and enforce, unquote. I'm personally delighted that this particular reporter understood your use of natural law before these hearings began. And I think he pretty well summed it up. Now, you've indicated to us that natural law is enforceable as a matter of adjudication only to the extent that natural law has been incorporated into the constitutional or statutory provision before you. Is that correct?
That's been accurate, Senator.
Okay, now many constitutional and statutory provisions do reflect or incorporate natural law and appropriately restrict private moral choices. For example, the 13th Amendment forbids anyone from choosing to enslave another, certainly another human being. There's nothing novel about this. Similarly, the Civil Rights Act of 1964 forbids hotels and restaurants from making the private moral choice to exclude black people or from being their patrons, and employers from making the private moral choice to exclude black people from jobs. Likewise, the Fair Housing Act restricts the rights of landlords and realtors to make private moral choices to discriminate on the basis of race. Now, Judge Thomas, I understand that it is your position that your personal views of natural law are not independently enforceable under the liberty component of the Due Process Clause. Is that correct?
That's right, Senator.
What you're telling us, as I understand it, is that your approach to the Due Process Clause would be similar to that taken by Justice Harlan, namely that history and tradition provide the substantive context to that clause.
That's right, Senator.
Okay. Now, isn't this approach to interpretation of the Due Process Clause that you and Senator Biden agreed upon as a traditional approach to the interpretation of the amendment? Isn't it a traditional approach?
Senator, I believe that the approach that I've suggested is indeed a traditional approach.
I need approximate minutes, Senator Biden. If I can. No, go ahead. Indeed, isn't it a basic principle of constitutional interpretation that we look to the natural law or other consideration when, but only when, it aids us in understanding the written law of the basic document?
I think we look to the framers' intent. We look to what they were attempting to do and an aid to interpret those provisions. I think that's correct.
So as I understand it, and I think anybody who's been watching these proceedings, who's listened carefully and would understand it, is it your position that natural law is not an independent basis for decision, but rather it can inform our understanding of the substantive context of the document, including history and tradition?
That's right, Senator. To the extent that the framers reduced their beliefs or their principles to the document, it could aid in determining what the framers thought.
Well, so in this regard, seems to me it's apparent that you follow in the footsteps of Abraham Lincoln and Martin Luther King Jr., who argued that natural law informs the Constitution. You agree with that?
I think it informs and inspires us the way that we conduct ourselves in this country, Senator, in our political processes.
Well, I agree with that, too. Let me just say in closing of my questioning that I don't think that we should have a single litmus test to exclude somebody from serving on the court. And I frankly don't think that it's fair to keep bombarding you with questions about abortion when you've said you're undecided on that issue. Now, any senator can ask any question he or she desires to ask. But I think there's a point where it's overdone. And in your particular case, I think you've been singled out. And I've even heard some senators say that unless you answer the question the way they want you to answer it, that they may not vote for you. Well, that's a decision that individual senator has to make, but I think it's an abominable approach. Because I don't think anybody should be rejected or should be voted against for the Supreme Court of the United States on a single issue or a single litmus test. I just don't. And if we get to that point where this becomes a politicization of the courts, we're all going to lose. I've been very proud of sitting here and listening to you, and I just personally want to congratulate you on the good way that you've answered everybody's questions and your demeanor and the approach that you've taken. I think you're doing a great job. Just keep it up.
Thank you very much, Senator Hatch. Senator Metzen.
Thank you, Mr. Chairman. Just make a comment before getting into another line of inquiry. My colleague from Utah wants to know why you are being treated differently than Judge Souter with respect to the question of a woman's right to choose. I think it's pretty obvious that all of them, that you have written very extensively and have spoken out quite extensively in this area, and I think it warrants that inquiry. Beyond that, I think there is a greater sense of alarm as to the direction in which the court seems to be moving, and I think that to fail to inquire of you in that area would be irresponsible on our part. But Judge Thomas, to another area. In the past, you and I have had disagreements over policies that you pursue at the EEOC. But there is one area of your record at the Commission which is particularly troubling to me, and that is your record with respect to age discrimination against senior citizens. Discrimination against the elderly does not always receive the same amount of attention or provoke the same degree of outrage as racial discrimination or sexual discrimination. But employers who dismiss or refuse to hire individuals because of age, as you know, violate the law every bit as much as employers who discriminate on account of race or sex. That's why, Judge Thomas, in reviewing your record, I was shocked to come across a 1985 statement you made in an interview with the American Bar Association, with the ABA Banking Journal, a banking industry trade publication. In that article, you suggested that discrimination against the elderly could be justifiable. You were quoted as saying that, quote, the age discrimination issue is as complicated an economic issue as any we confront in the equal opportunity area. You continued on, I am of the opinion that there are many technical violations of the Age Discrimination in Employment Act that for practical or economic reasons make sense. Older workers cost employers more than younger workers. Employee benefits are linked to longevity and salary. In an economic downturn or when technology causes staffing changes, employers tend to eliminate the most experienced and costly part of their workforce. End of your quote. Judge Thomas, at that time, you were the chief federal official in charge of enforcing the law against age discrimination. Yet here you were characterizing age discrimination as an economic issue, and then stating that many violations of the age discrimination law make sense. My question to you is, how could you, as a public statement which could easily be interpreted by employers as condoning violations of that law?
Senator, if you could, if I could have the whole quote, it would be helpful to me so I could look at the context. But let me say this. I have never condoned violations of the Age Discrimination and Employment Act. In fact, just the opposite. The act itself has made some very difficult decisions. For example, in the mid-'80s, the act itself covered the ages from 40 to 65, and then from 40 to 70, actually earlier than that, from 40 to 7, then uncapped during the 80s. The Age Act also makes clear that there can be factors other than age that could result in those sorts of distinctions. That's in the statute. Those aren't my decisions. I have not, do not, and never did condone discrimination, unlawful discrimination under the Age Discrimination and Employment Act.
Judge Thomas, what concerns me is that when the chief federal official in charge of enforcing the age discrimination law says that many technical violations of that law make sense, it sends a signal. It suggests both to employers and even to EEOC personnel that age discrimination issues are not a high priority within the commission. Weren't you concerned about sending that kind of signal? And it's my understanding that you do now have a copy of the article.
I have a copy of the article. The point that I'm making is this. To individuals, and I don't think that I suggested that it made sense to or condone the violation of the act, but it would make sense to an employer to think that, well, this approach is okay. That's a violation of the Age Act to say that we are going to pinpoint or focus on older workers. The important issue is not so much for me whether or not the individual, the employer says we want to make the decision of downsizing our workforce. The employer says, well, that makes sense. Perhaps what we could do is look for the highest paying job. Well, that might make sense to the employer. The problem for us when an employer makes a decision of that nature is, does that violate the Age Discrimination and Employment Act? And as you remember, during the 80s, during those significant downturns, during those mergers and acquisitions, employers were making those decisions, and we were bringing a significant number, a larger number of lawsuits to counter that. So it might have made sense to them. The problem is that it violates the Age Act.
Well, my point is that it sort of indicates that you weren't sending a signal, but you made that statement to the ABA Banking Journal, which, as you know, is a trade journal for the banking industry. Now, would you have made that same statement if you had an interview with the AARP's publication? I think you would have said that many technical violations of the Age Discrimination and Employment Act make sense.
I think, Senator, if you would look at the whole article, the point that I was trying to make in the article, and I haven't had a chance to review the entire article, is that we were actually upgrading enforcement. That indeed this is one area that was technically very complex. That indeed employers were at a greater risk. Later in the article, for example, and I just had a chance to skim it here, I say, under Thomas, the EEOC has changed the system that investigates all cases that fail conciliation. Well, that's actually a misstatement, but about 85 to 90% of cases probably will go on to court, Thomas said. That's an increase in enforcement, and that is something that we did over time. The article also refers to, I believe here, the automation programs that I was beginning at that time so that we could better enforce the law. I have not in any place condoned a violation of the Age Discrimination and Employment Act. These efforts on the part of employers may make sense to them. But if they're wrong, they're wrong. If they violate the act, they violate the act.
Well, I guess words speak for themselves when you say that technical violations are make sense. I think that certainly sends a signal. In that same interview, after you assert that there are many technical violations of federal age discrimination law, which makes sense, you go on to say, quote, older workers cost employers more than younger workers. Employee benefits are linked to longevity and salary. In an economic downturn, or when technology causes staffing changes, employers tend to eliminate the most experienced and costly part of their workforce, end of quote. Now, Judge, many older workers, as you well know, these are the people who built the company. They were there for 20, 30, 40 years. They're loyal, long-term employees. The courts have consistently held that employers may not target older workers for layoffs. In a 1988 opinion of the Seventh Circuit Court of Appeals, after examining cases that were decided well before you made your statement, that case summarized the law in this area by stating, quote, courts have emphatically rejected business practices in which the plain intent and effect was to eliminate older workers who had built up through years of satisfactory service higher salaries than their younger counterparts, end of quote. In view of that court decision and the law, the specifics of the law, why would you publicly suggest that it was sensible for employers to lay off older workers because of higher salaries when the courts had made it clear that the age discrimination law forbids such a practice?
Senator, let me repeat what I've said. It may make sense to the employer, but if it's a violation of the Age Discrimination in Employment Act, it is a violation. We at EEOC, I think, pursued those cases aggressively just because it's logical to them that this is an area that perhaps they could make changes. If it's a violation of the Age Discrimination in Employment Act, then it should be addressed. Those cases were investigated to the best of our ability. They were litigated and they were pursued. As you remember, during that time, those were difficult issues in the downturn in the economy. And I think that we wrestled with them in a professional and an appropriate manner. There were differences of opinions as to how that should be best done. I don't think that I am saying here that it is okay, that it is acceptable, that it is fine to violate the law. The line that I'm trying to, I think, and I haven't had a chance to read the entire article, to point out here is this, that it does perhaps make sense to the employer, but that's a violation of the Age Act.
Say that at times?
I did not. Again, I didn't write the article, Senator. If I had the whole interview.
I understand that, but the point is, the article quoting you, and there you're saying to banking industry that many technical violations of the Age Discrimination Law and Employment Act make sense for practical and economic reasons. You don't put any qualifier on it. You don't put any condition on it. You don't say it's still a violation that you're going to prosecute those cases. You're sending a message. You understand that there are some violations of the age discrimination law that make sense, and that's the concern of senior citizens. It's concern of many people in this country.
Well, Senator, you ask, or you state that I put no qualifiers on it. The point that I'm making is that, one, I did not write the article. Perhaps I gave an interview. But at no time did I endorse or permit or allow violations of the Age Discrimination and Employment Act. If someone were to ask me the question, do you find that there are violations out there? Why is it that employers are running into violations in the new era of mergers and acquisitions? Why are they having more violations of the Age Discrimination and Employment Act? And I say, well, perhaps they think it makes sense or it makes sense to do this. But that is not an endorsement of a violation of the Age Discrimination and Employment Act.
You didn't say what some others might think. You're saying, I am of the opinion. That's a quote. I am of the opinion that there are many technical violations of the Act, the Age Discrimination and Employment Act, that for practical economic reasons make sense. And it's you who is speaking, not somebody who is interpreting your words. The Age Discrimination and Employment Act requires older workers to file their age bias claims with the EEOC. The Commission is authorized to investigate the claim, and if it has merit, attempt to work out a settlement or file a lawsuit on behalf of the older worker. The Age Discrimination and Employment Act has a 2-year statute of limitations, meaning that either the EEOC or the older worker who brings the age discrimination charge to the EEOC's attention must file a lawsuit within 2 years of alleged acts of discrimination. If not, the older worker loses his or her right to seek redress under the law. As you well know, unfortunately, during your tenure as head of EEOC, thousands of age bias claims sat languishing in the EEOC for over 2 years. As a result, thousands of older workers lost their right to bring lawsuits under the ADEA. Congress did not become aware that there was a system-wide problem within the Commission until late January 1988. Then, as you know, Congress moved quickly to pass special legislation in April 1988, which restored the rights of those older workers who believed they had been discriminated against. As I mentioned in my opening statement, the problem of lapsed age cases happens not once, but twice this time. For now, let's focus on the first batch of lapsed cases. Your agency's own internal documents show that as far back as January 1986, Commission members, including yourself, were aware that EEOC field officers were having trouble meeting the statute of limitations on age discrimination cases. A January 1986 litigation memo presented to all 5 commissioners, including you, stated that even though there was substantial merit to one age case, the General Counsel's office had to recommend against litigation, quote, primarily due to statute of limitation problems, end of quote. An April 1986 litigation memo presented to all 5 commissioners, including you, in another meritorious age case stated that, quote, the statute of limitations is already operating to bar individual claims on almost a daily basis, end of quote. I have 2 questions for you, Thomas. First, how could these lapses have happened? And second, given that there were early warning signs going back to January 1986, why did it take almost 2 years before the Commission discovered that it had a system-wide problem which was causing thousands of older workers to lose the chance to vindicate their rights?
First, Senator, with your permission, I'd like to just simply comment on, to the extent that there's any question about my view of enforcing ADEA claims from the last vote. My point is and remains firmly that I would not tolerate nor permit any violation of the Age Act. With respect to this particular problem, as you know, this was a very difficult problem and a very difficult period for me during my tenure. I am a lawyer, or I was a lawyer before I went on the bench. And one of the things that I can remember early in my own tenure as a lawyer is making that panicked midnight run to the law office I thought that when others heard the word statute of limitation, their reaction or that panic set in the exact same way. If I could have investigated every single one of those age charges, I would have. That was the low point of my tenure. I said it then, and I say it now. I don't have the presentation memos that you're talking about, but let's put that in context a second. If you want to get to them in detail, I'll just do that, but let me talk generically about the problem that we were facing in the mid-'80s. First of all, the initial inkling of a problem that we saw was that when cases were presented after they had been investigated in the field, and those cases were then sent to our headquarters, they were sent to our general counsel's office. When those cases came in any number of areas, we found that there was this problem. The problem was, whether it was Title VII or the Age Discrimination Employment Act, the cases would sit in that office for months and sometimes years. We immediately changed that policy. I think I changed it sometime in the early 80s, perhaps 84, 85, so that when these investigated cases recommending litigation came from the field offices, they immediately came to the full commission. As a part of that, what we noticed was that cases could, while sitting in the general counsel's office or in the regional attorney's office in the district offices, they could miss the statute of limitations. That was a separate problem from the one that you and I have talked about. One of the things that we did was this, with respect to those cases. The problem with respect to the lapse is separate from that. That's an administrative problem in the field offices. It's not a problem that comes from the period that the cases are sent to the headquarters office, and then those cases sitting there waiting to be attended to by an attorney. The administrative problem resulted from this. When I went to EEOC, there was a process. EEOC did not investigate routinely age discrimination charges. Myself and the other commissioners felt that they should be investigated. And we introduced a policy to do that. That took more time. The second component of that is this, that the Age Act has a 2-year statute of limitations, unlike Title VII. Our first initiative, when we changed the policy, recognizing that it would take longer to investigate the cases, was to require the district directors to monitor their workload more closely. Some district directors, unfortunately, did not do this, and unfortunately, some cases missed the statute of limitations. I found out about this in December of 1987. I notified Congress as soon as it returned from the Christmas break, and my staff, or EEOC staff, worked closely with your staff to develop legislation which was introduced and passed and enacted, I believe, in April.
Judge Thomas, I guess that's the issue with you that Congress acted as your behest.
No, we cooperated with it.
Well, you didn't oppose it. In 1988, reports of the staff of the Senate Aging Committee concluded that the EEOC misled the Congress and the public on the extent to which age discrimination charges have been permitted to exceed the statute of limitations. That's a quote. The report states that when it initially requested data on this issue in September 1987, the EEOC responded that only 70 cases had lapsed. But at that time, an internal EEOC survey revealed that over 900 federal age discrimination charges had lapsed the statute of limitations. In December 1987, the EEOC told the Aging Committee that only 78 cases had lapsed. But a trade publication reported that nearly 988 charges had exceeded the statute of limitations. 1 month later, in January 1988, you formally advised the Aging Committee that 900 cases had lapsed. Senator David Pryor, the current chairman of the Aging Committee, has stated that, quote, after months of To obtain additional and accurate information on this matter, the Aging Committee issued a February 1988 subpoena to Chairman Thomas to provide data on the lapse charges, end of quote. The EEOC now acknowledges the age bias claim of over 4,000 workers lapsed due to your agency's failure to process those claims in a timely manner. Both the Senate and the House Aging Committees have estimated that as many as 13,000 older workers may have lost their rights due to your agency's inaction. Congress is trying to find out the extent of the lapse cases problem at your agency. The Senate committee, which deals with senior citizen issues, is attempting to determine whether older workers are losing their rights. The current chairman of the committee has stated that the committee's efforts to inform itself on this issue were being frustrated. So a subpoena was issued. 10 Democrats and 3 Republicans on the committee supported the issuance of the subpoena. No member of the Aging Committee objected. And yet here is how you characterize that subpoena in a speech prepared for delivery on April 7, 1988, the exact same day that the President signed the law passed by Congress restoring the rights of older workers. You said, quote, "My agency will be virtually shut down by a willful committee staffer who has succeeded in getting a Senate committee to subpoena volumes of EEOC records. It will take weeks of time and cost hundreds of thousands of dollars, if not millions. Under the guise of exercising oversight functions, the staffer seeks to implement the programs of the American Association of Retired Persons. Thus, a single unelected individual can disrupt civil rights enforcement, all in the name of protecting rights." Those comments were absolutely astounding. Congress is trying to find out the scope of a problem that affected thousands of senior citizens. Congress had to have sufficient responsibility in restoring the rights of lapsed citizens because the statute of limitations had applied. We were trying to find out how to keep it from happening again. You declared that the Aging Committee acted improperly in issuing a subpoena to determine whether or not your agency had neglected the legal rights of thousands of older workers. You also maligned the integrity of the committee, which issued the subpoena. It was not my committee, it was Senator Pryor's. You suggested the committee was doing the bidding of the American Association of Retired Persons. The question, Judge Thomas, is how could you, on the very day in which the law bailing out your agency went into effect, condemn so vehemently Congress's efforts to find out whether older workers were still losing their rights as a result of your agency's inaction?
Senator, there's quite a bit there. We received on a Thursday afternoon a very detailed request from the Senate Select Committee on Aging, then under Senator Melton, concerning very detailed information over a Labor Day weekend at EEOC. The request, which was not handled directly by myself, but by our legislative office and our administrative people and our general counsel, the request was for a variety of data, including charges. Those are the administrative charges that come into EEOC and cases that have passed the statute of limitations. Our personnel separated those tasks, the request for charges and the request for cases, and took those requests assigned those to the relevant officers. The requests for cases were assigned to the general counsel's office. The requests for charges were assigned to the administrative people. The document request that we responded to about the numbers that had lapsed, that had missed the statute of limitations, was the request response from the general counsel's office concerning cases, not charges. There was no effort ever to mislead the committee. In fact, we attempted to have the committee clarify for us precisely what it wanted us to respond to in such a short period so that we could do that normally, that when a request comes to EEOC, the request or the requesting body sits down with our staff people, and we go through the documents, we go through the request, and we determine how to respond. In this instance, that did not occur. Now, with respect to learning about the missed charges as opposed to the cases, what we attempted to do was, as soon as I found out, was to not only inform Congress, but to make it public. I found out in December of 1987 and reported to Congress when the day Congress returned for the next term in January.
It's about to expire, but I want to make it clear before it does, that when these last recent cases you seemed right, you stated it wouldn't happen again. But as we all know now, after Congress passed corrective legislation in '88, the problem didn't go away. You didn't take care of it. Thousands of cases continue to lapse due to your agency's failure to ensure that the claims were processed in a timely manner. We had to pass a separate bill in October of 1990 due to the inaction of your commission. And as a consequence, costing thousands of aged workers the loss of their rights.
Senator, we did everything, and I certainly, during my tenure, with the resources that I had, we have a very spread out agency to respond to that problem. As you remember, it's a difficult problem. If I could have investigated every one of those cases, I would have. There were approximately 2,000 cases within the EEOC or charges within the EEOC which had missed the statute during over a 4-year period. Out of the approximately 50 to 60,000 that we receive a year, and I believe approximately 100 cases did involve there was a finding of discrimination. But even one, as I've indicated, is too many. We took steps to solve the problem. We automated or complete the automation of the agency so that the cases could be more accurately tracked as opposed to the headquarters and the receiver offices. We sent notices to the individuals so that they would know when the statute was approaching. We held managers more accountable. We had done that before, but we redoubled our efforts. The point was that we're trying to make an entire agency respond to something that I felt strongly about, and I know that you felt strongly about. It was enormously frustrating. I did as much as I could possibly do. I did not want a repeat of that. In fact, I never wanted it to happen. But getting an agency to respond, a bureaucracy to respond, is sometimes far more difficult than wanting it done.
Thank you, Mr. Chairman. Well, lots of things to talk about. I do agree, and I want to say that I agree with Senator Hatch about the issue of abortion. I don't know how many times you can ask that question, and however many times it will be asked, it will be answered in the same manner. But it's interesting to me to hear the continual response and continual asking of it, because I couldn't help but think, after being on this committee for 13 years, and back in 1980, Senator Metzenbaum, who was in the majority, and chairing hearings with Judge Ruth Ginsburg, was very clear on this issue that seems to have taken over a good deal of discussion, and that is, what questions should we ask you? Senator Metzenbaum was saying in connection with the Ruth Ginsburg nomination, and he chaired that as ably as he does his work, and talked about her statement and said, you don't mean that every nominee up for confirmation ought to have his or her views explored as to what his or her positions are on all of the controversial issues that may come before those jurisdictions. You don't actually mean that, do you? That's a quote, Senator Metzenbaum. And then then he went on to say, do you think the Judiciary Committee members in days of yore should have refused to confirm Justice Black, who had been a member of the Ku Klux Klan and went on to become one of the more liberal members of the bench? Do you think that they would have been doing their job right, or would the nation have suffered or gained if he had not been confirmed? And then it was said, should we then vote against her, or should we look at her and say, is this a person who has the kind of integrity, temperament, ability that can make a good or a great jurist? And if he or she has, then regardless of our agreement or disagreement with his or her particular views, shouldn't we then, under those circumstances, send that nomination to the floor with our recommendation? And I concur totally with those views of my senior colleague from Ohio. And that's the way it works in this place. Senator Kennedy, and I've served with him and enjoyed the service with him on this committee. He said in a hearing with regard to Justice Day O'Connor, he said, it is offensive to suggest that a potential justice of the Supreme Court must pass some presumed test of judicial philosophy. It is even more offensive to suggest that a potential justice must pass the litmus test of any single issue interest group. The disturbing tactics of division and distortion and discrimination practiced by the extremists of the new right have no place in these hearings and no place in the nation's democracy. I just happen to think, as I looked at that what's true for the new right is also true for the old left. So that's an interesting thing. But what it shows is that there isn't a thing we couldn't find here, than what we do, of those of us on this committee, where we haven't said one thing one time 4 years ago or 5 or 10, and another thing last month. I've done it, and I can tell you, if you've been in politics long enough, the wheel will come around and kick you right in the rear end. And that's the way it works. And so to put this test on you, and I think you've explained it pretty well, but I think you maybe ought to just say, you know, I've done some things when I was a politician that I sure wouldn't do as a judge. And then we would understand it better. It would fit. It would be something we could grasp. And then you wouldn't have to say that you were quasi-public person or that you were in the executive branch. Just say you were a pretty hard-hitting politician at one time. You worked for a president, helped get him elected. I didn't know, did you ever do any precinct work or hack around in that stuff?
No, Senator.
Ooh, you missed something. We've all done a little of that, I think. But if you were just to reflect, you know, that obviously the things you said as you dealt with emerging thoughts and as a political person serving a president of your party and then part of the executive branch, I think those things need to be very carefully segregated as to importance. And unfortunately, I think it's kind of sad to see it turned into something as if it were a confirmation conversion, when there isn't one of us here that could pass that test. You won't pass it either. But it doesn't have a thing to do with our integrity or with our honesty. And you made some certain promises to this panel when you started as to what you would do. Said you would serve with honesty, integrity. It's a very beautiful statement, and it's already in the record. But we as politicians have learned that when those things happen to us, we call it a maturity in thinking that has overcome us, or evolution of mental weighing of the issue. We don't lay bad things on it because this is the way it is. Facts change, things change, people change. So I think that's very important. I'd be quite hurt if I heard people impugning your integrity or your honesty or your character. You handle that one a hell of a lot better than I would. So now if I might get to the Select Committee on Aging, I must be one of the last of the line. I serve on that. Let me tell you what happened when I got on there, because I wanted to get on just see what was going on the Select Committee on Aging, and what was going on with you was a vendetta by a senator who is no longer in the United States Senate and a staff that had just gone on an absolute hunt. And I know because I used to show up occasionally and pop my head in, and I'd say, what's going on? And the staff members just kind of stood around and kind of salivated. They said, well, what's going on? We're going to get into the EEOC. And it was very curious to me that everything that has been presented here by the senior senator from Ohio has all been presented before. There's not one thing here that hadn't come up before, and that was before you went on the bench before. Because this was the only stuff to use on you, and I won't want anybody to believe that this is new stuff, or that somehow this terrible thing that has happened is all brand new. You could go back and look at the record, go back and look at the Select Committee on Aging record, and it was not at the direction of Senator Pryor that this occurred. It was at the direction of his predecessor. And it got so bad that the members didn't even show up anymore. Now, let the record show that. And let the record also show that after all those months of wasting your time and ours, nothing came of it. Because you had a committee staff that never even understood the difference between a charge and a case and couldn't even compute it correctly, and it was appalling to watch. And along came Senator Pryor, our wonderful colleague who's back with us now. I can tell you he made some sweeping changes in the staff of the Select Committee on Aging. There ain't anybody left that was involved in that kind of absolute extreme activity. So the exaggerations as to the charges and criticisms of your handling of age discrimination cases before the EEOC is really, really old laundry. And some of those exaggerations came from a very tenacious group in the community known as the AARP. I have dealt with them before. I had a full head of hair before I got into it with them. But I can tell you, they're tough. And, you know, whenever we do something that affects them, they say, don't forget there's 32 million of us out here. Of course, that includes the magazines on dentist stands anywhere in the country, too, of modern maturity, which is a better magazine than the Smithsonian. So that's what they said. Actually, I think the distinction is that it is of the same paper quality and print quality, but the interesting thing is that in it, the advertising is some of the sleekest gray-haired cats you ever saw. But all the editorial comment is how everybody over 65 is somehow underprivileged. And they lose some credibility in that, and that's how I lost all this hair. So the AARP led that charge with a senator who was willing to lead it, a senator who was no longer in the Senate. And it was a bust. It didn't go anywhere. It was an embarrassment to some. Another of our colleagues who is no longer with us was the ranking member on that committee. And if he were here, he would put all of this stuff to bed. And that was our friend John Hines. So Well, I hope we won't spend too much time on that. It was brought squarely before the Senate, and who brought it to the Senate was you, because your predecessors surely didn't. And so every single bit of this was presented to the United States Senate by you. And the Senate considered every one of these criticisms in total and rejected every single one of them when we confirmed you previously. So I hope we can keep that old, tired issue in its proper perspective. I think that Senator Metzenbaum quoted a news article, if I heard correctly, to the effect that you said that some violation of age discrimination laws made economic sense to some employers.
The ABA banking magazine.
Okay. I guess the implication was that not only you understood that, but that you also approved of that. Did that get clarified?
I think my final comment on that was that I in no way endorsed any violation of the Age Discrimination in Employment Act. So I think I did say what my view of it was. I certainly would not have intended to do that.
I don't think you ever misled this Senate Special Committee on Aging, not from the times that I knew or my staff was there. When I was not there throughout because I finally just got tired of it. Too much it was so feckless, so silly. But I don't believe that in any sense ever you misled. And I often thought that you were being blamed for the inability of the Aging Committee staff at that time, their failure to understand what it was that you did or what the agency did, especially with regard to the interchangeable use of case and charge. I think that 13,000 figure has been terribly overblown, and that, of course, has been covered rather thoroughly. So I just wanted to make those comments with regard to the Select Committee on Aging and its hearings on you. Do you have anything to add to how you felt that came about and what the results were as you perceived it after you sat there patiently for many hours with your staff? What is your assessment of that?
Senator, as I noted to Senator Metzenbaum, that was an enormously difficult period. There were misunderstandings about information early on. It required a redirection of an enormous amount of resources in the agency. And it was a problem that was difficult to solve, and we recognized that. It was a problem that we had to solve with limited resources, and we recognized that. But the point is that we took every step possible, and ultimately, with a refocusing or redoubling of our efforts in paying attention or having the agency staff pay more attention to the statutes of limitations, as well as finalizing a computer database, not a perfect database, but a working computer database, we were able not only to track the time-sensitive age discrimination charges, but we were also able to monitor and to send out notices to the charging parties involved. Prior to that, and I'll end on this note, we were unable to even discern what we had in the agency. We could in no way tell you what kind of problem we had or what was even there. We did not have the database capability. I think the recognition for us was, and it's an important recognition, is that those time-sensitive charges, perhaps we should have thought about tolling the statute in some way legislatively or perhaps some other action. But when you attempt to fully investigate time-sensitive charges, it requires that you do more and do it more quickly. And remember that EEOC receives about 60,000 charges a year, and that's something that requires us to manage our work more closely, and we tend to do that.
I've noted in recent weeks that your predecessor has been very critical of you, and she speaks critically of you in various forums, which puzzles me because a lot of all of this happened before you got there. And I'd like to enter into the record the General Accounting Office report of April 1981, saying that the rapid charge process has overemphasized obtaining settlement agreements, with the result that EEOC has obtained negotiated settlements for some charges on which GAO believes there was no reasonable cause to believe that the charges were true. The settlement agreements for these charges have little substance, and they distort the results of the rapid charge process by inflating the number of settlements. That's just part of it. I think it ought to all go in the record. And then, if I might return to this issue, and because you get into, and I talked about abortion, but let's get to privacy. That keeps coming up because it is an attempt, and you handle it very deftly, to simply lead you from the issues of privacy to abortion. And that hasn't worked so far. It didn't work with anybody that I have had the opportunity and the pleasure to serve on this committee while they were presenting themselves to the Senate. Sandra Day O'Connor, Justice Kennedy, Justice Scalia, Justice Souter, none of them answered these questions. But just a quick word on privacy. You told me in a private meeting earlier this year that you honestly had not made up your mind on the terribly searing issue of abortion. I accept that statement. And it's tough for me because I am pro-choice. I've always believed that a woman should have this choice. And it didn't come from confirmation hearings. It came from practicing law with real live human beings. So I've not come to that position through a rigorous analysis of the U.S. Constitution, but through life as a lawyer, dealing with real life problems of real life people in extremity, who came to me for, I hope, honest and real assistance, and that's what I tried to give. Like, I'm going to commit suicide if I have to carry this child to term. And that's when, as a lawyer, a male lawyer, you really don't want to go much further. At least I didn't. So at least here is what I hope is my common sense, real-life interpretation of privacy and how that might extend to a right to abortion. Privacy in the West is a very extraordinary thing, perhaps not more than any other state in the Union or place in the Union, but in Wyoming, by God, it's the right to be left alone. And it means a lot to people. And this often mentioned doctrine of family privacy protects against legislation that interferes with certain universally respected rights. But family privacy is not an absolute. It does have some limits. Few things are absolute. It seems its most appropriate power is when it protects the right of one individual without imposing on any way on the rights of another individual. The Supreme Court has clearly established that a family has the right to send their children to a private school. That's the Pierce case, that a family may decide which family members may live in their home. We've talked about that one, East Cleveland. The family has the right to decide whether or not to practice contraception, Griswold, all in which I concur. However, that family privacy doctrine is not absolute. A husband or wife does not have a family privacy right or a constitutional right to batter and maul the other one. And according to Roe versus Wade, a woman does not have an unfettered right to abort her unborn child once the fetus has become viable. Family privacy then does stop at certain barriers and boundaries when the right of one person impinges on the right of another. My question to you is this: is not the family privacy doctrine a question of degree and not an absolute, clearly defined thing in stone?
Senator, the courts have wrestled with defining the contours of the right of, that important right of privacy. I think I come from a part of the country where privacy is treated pretty much as the way that it's treated out west, that you really value privacy, learn to respect your neighbor's privacy. You don't just ride onto someone's land without being invited. You certainly don't walk into someone's house, and definitely not their bedroom without being invited. So it is important. The court, though, has wrestled with how far does this right extend? What portions of this right are to be considered fundamental? And those contours, I think, over time will be defined in Supreme Court cases.
Is it? It is not. Isn't not inevitable that reasonable people would disagree about whether a woman has the constitutional right to abort a non-viable unborn child?
It is certainly an issue in the general public that people have very strong opinions about, and as I've indicated earlier, I can understand the depth of feelings and passions on both sides of the argument.
Well, many special interest groups and many politicians paint abortion as some black and white issue. And by personal experience, that abortion is a numbingly difficult and anguishing and ghastly issue just because it is not a black and white issue. The toughest one, perhaps, that could ever be made by a woman. And but in my mind, that's the only person that can make that decision. I feel very strongly, so I ought to be really zeroing in on you more. But I'm not, because these other things that we're going to see, and we do see about you, integrity, honesty, character, judicial temperament, you've got that, my friend. I don't know who's keeping the scorebook, but judicial temperament. You have won the Oscar, because I can see you on a bench in the midst of clamoring counsel. You won't get as many in the U.S. Supreme Court, but they're there. So, in my mind, that decision should be made by the woman, and I have trouble with it myself. It should not be made by legislators or judges, especially male legislators and male judges. I'm going to ask you only one more question on that topic. It won't be the last one you'll hear, I can assure you that. Do you promise? You used the word promise when you sat before that first day. Do you promise this committee to consider the abortion issue as you face it on the court with an open and equitable and fair mind, and with sympathy and compassion for all who are involved?
Senator, I would not only make that promise on this important issue, not only to this committee, but to, if confirmed, to the American people and to myself, solemn oath. I cannot sit as a judge if that is not the way that I proceed on those cases. And that is a promise that I take very deeply and understand, appreciate, and feel strongly about on all cases, that I approach them with an open mind and for the individuals involved with an open heart.
One final point. Earlier this morning, Chairman Biden asked you about the, I think it was the 72 Eisenstadt case, which held that a state could single person from purchasing contraceptives. That holding was extended in a 77 case of Perry versus Population Services, which struck down a New York statute which allowed only licensed pharmacists to distribute contraceptives to persons over 16 and prohibited the sale of contraceptives to persons under 16 except by prescription. However, these use of contraceptive cases do not imply that there is a fundamental right somewhere of privacy for every single aspect of sexual relations, do they? In other words, for example, the court ruled in '86 that there was no fundamental privacy right to engage in homosexual sodomy. I believe that was the decision. And I asked this question because I think you were hindered by a lack of time in your response, partly because of my urging to conclude. And so I would ask you to conclude that. I don't know that you did. I'm not here to rehabilitate you. I didn't hear what came out. Did you have anything further to add on it?
Nothing more than this, Senator. The Supreme Court, as I noted earlier, has wrestled in cases such as the one you just mentioned, Bowers v. Hardwick, with the contours of the right of privacy. And it is a difficult area, and it's one that I'm sure that the court will be revisiting. But beyond that, I think that my comments on the whole issue in the area of privacy have been pretty full.
Well, Mr. Chairman, I will go on to a different subject, and there's no time for that, but I did want to share with you. No, that's fine. I'll come back. I'm going on to the issue of affirmative action. I wouldn't have time. But I did want to share with you what I found on the outside of the Justice Department building. Would you like to hear that? Up on the wall there? Yes. What's that?
I'd like to set it to the afternoon.
You like me to go on? Are you trapping me? Oh. You would like me to? No, I shan't.
I'd love to hear what.
No. This is over the main entrance.
Etched in, or
This is just.
graffiti?
This is in my 35 seconds left.
I don't want any graffiti.
No, it's no graffiti. I didn't put it on there, nor did any of the committee. It says, over the main entrance to the Justice Department at 9th and Pennsylvania Avenue in Washington, D.C., it says, quote, "Justice is founded in the rights bestowed by nature upon man. Liberty is maintained in security of justice," unquote. Isn't that fascinating? I just thought I'd throw it in there.
It's not only fascinating, I wish more judges believed it. We will recess for 10 minutes.
A lighter note, at the Senate hearings on the nomination of Judge Clarence Thomas to succeed Justice Thurgood Marshall on the Supreme Court, and an afternoon break now. This is the third day of these proceedings taking place before the Senate Judiciary Committee. The hearings taking place in the old Senate caucus room. And once more, Nina, this afternoon we're getting a round of questions primarily directed at the way Judge Thomas administered his job when he was in charge of the government's Equal Opportunity Commission.
That's right. And for the first time, we are beginning to turn away from some of the issues of abortion and privacy. And this afternoon, we focused on the well-worn path, at least in Clarence Thomas's previous confirmation hearings, of his administration of the Equal Employment Opportunity Commission, most particularly his administration of age discrimination complaints. And there were some 13,000 age discrimination complaints that lapsed without action, lost their legal ground for existence because of the inaction of the agency when he was its director. And Congress twice had to pass legislation to rejuvenate those complaints so that all those people who were covered by the Age Discrimination Act would not lose their grounds for lawsuit. Now, today, Chairman Thomas said, as he has before, he has been the chairman, he said, as he has before, that this was his lowest point as administrator of the EEOC, and that he was, if one can overstate it slightly, grief-stricken almost by this. And his friends have said it was a profound embarrassment to him. And he says he brought it to the attention of the Congress that he did everything in his power to fix the situation, but that it takes time to make a bureaucracy come into line. Now, the groups that represent the elderly, and most of the members, at least the Democratic members of the committees that oversee the administration of this law, have a different version. They claim that the EEOC really misrepresented the facts before Congress, that Mr. Thomas, when he was chairman, tried to punish members of his agency who squealed to Congress, who whistle blew to Congress. Some of the members of these committees are formally opposing his nomination now, and some in the past have voted against his confirmation at other times. So I imagine this is going to be revisited, and you heard Alan Simpson this afternoon take out after the American Association of Retired Persons, and we'll probably hear more about that. So at least we've gotten away from the subject of natural law a little bit this afternoon.
Right, into a natural controversy, as it were.
Into a natural controversy.
We should say that Clarence Thomas, for his part, said several times that he never condoned any violations that constituted age discrimination. He denied that he tried to impede the law, that he actually increased the enforcement when he was at the EEOC. He endeavored to explain the operations of his office in a way that suggested that he just had a different philosophy in terms of administering the law. And he tried to show, too, denying some of the suggestions from the Democrats, he tried to show that he did not engage in any kind of foot-dragging enforcement of the law. But, as you suggest, Nina, this clearly is an area of dispute where people have different ideas about how the law was handled when Clarence Thomas was head of that agency for some 8 years. Well, the senators have been patiently sitting through these proceedings now for 3 days, and one of those senators is with us at this moment, Democrat Howell Heflin from the state of Alabama. Senator, what is your assessment of Clarence Thomas's performance so far?
Well, I reckon it's mixed. I suppose it's controversial nomination has ever met with universal approval or disapproval, and except by those that make up their mind as soon as the president nominates. There's some that, if the president nominates, they're going to be for him, and then there's some that are going to be against him. But they are, I think, a good number. They want to hear the whole evidence and go through the hearing process before they make up their mind. But I think he's come across from a viewpoint of his appearance of temperament. He's very calm. He's very cool. He is deliberate. He controls emotion. Hasn't shown any emotion. I think he's come across in the aspect of appearance temperament that he would make an excellent judge. I think someone said he'd win an Oscar. I think Simpson said he'd win an Oscar in regards to that. Substantive temperament may have some questions about it, as well as other matters relative to this as we go along.
Are you at all concerned that he seems to have shifted his viewpoint on some of the major issues?
Well, I don't think there's any question that there's been, from what we thought the Clarence Thomas was and what he thought and everything before, is that he is coming across different. He's much more moderate. I would assume, for example, that many of the extreme right wings groups may be worried about it now. He's come out saying that he does not believe and will not involve the law in regards to constitutional adjudication. He's come out in favor of public housing. He's come out supporting minimum wage. He's come out with some... I don't know. That remains to be seen. A lot of these were not asked of him before. Of course, the term confirmation conversion is it's a term that can have degrees in it too. And I think I stated, I was probably one of the first in this one to state that he gave it an appearance of it. Now, I use the word appearance because I'm not convinced yet that he has, but nevertheless, that's one of the factors that we will be looking at relative to the overall value.
It does raise that fundamental question, doesn't it? Who or what is the real Clarence Thomas?
Well, you know, some have the feeling that he may be a closet liberal by now. And, well, you know, at least he is, from the ideas we had where he was pretty rigid on what we thought, relative to natural law and other things, he's moved towards the center at least a lot more than what a lot of people thought where his position was.
I want to ask you a political question, Senator. During the Bork confirmation hearing, African Americans in your state were extremely active against the nomination. Joe Reed is one of the chief political officers in the state, was extremely active in organizing the minority population in particular and trying to get you to vote against Bork, which you in the end did do. You were one of the most scrutinized and swing and important votes. We hear that this time around, Mr. Reed and others in your state are not nearly as politically active. Is that true?
Well, I haven't heard Reed as to his position
Well,
on the
that
matter.
tells me something right there, doesn't it?
And I hadn't heard from a lot of political. Now, one group called the New South Coalition has supposedly voted. The communication I received from them was a copy of a press release. So I haven't heard from a great number of black politicians or leaders as I did in the Bork matter.
So this is really very different.
Well, I would think so. The intensity there and the intensity in regards to the people that supported Bork, what you might say the right wing, you haven't heard as much from them. It's from either side. I don't know whether it's an assumption that the Republicans now have the appointments on the court and it's going to be conservative and things are going to move and this is just an addition. I think that the Bork fight was more of a recognition that this is the key fight. Now, since Bork, you've had Kennedy and you've had Truman. Now you're in a situation where this just may be another number added to it.
On the basis of what you've heard thus far, will you vote for confirmation?
Oh, you wouldn't expect me at this time, being the former judge and viewing the tape, I'd never make a decision until after the hearing is over and done some further research. So it's too early, premature. The Senate ought to turn a person loose before the hearing is over.
Well, I'd like to know how you may be leaning at least.
Well, you know, I used to tell him I'm leaning straight up, but I'm not making any statements about that.
But among your Democratic colleagues, do you have any sense of real trouble for the nomination?
I sense not so much from the committee, but that I sense in the Senate as a whole, and people that come up and talk to me, and people that I have, that he's got more support than Bork among them. I don't know how that, I can't say that about the committee, but I'm saying that about senators and some senators that I would classify in the Democratic side as being in the moderate to the conservative element.
Well, of course, Bork was defeated. Does that mean that he has sufficient support to be confirmed?
Well, it remains to be seen and how it comes along. But I would say that if a vote is taken today, it'd probably be confirmed just from what I've heard. Now, that doesn't mean that I'm that's not reserving it, but right today, from what I hear among my colleagues, there is like there's none of Georgia indicates has done it. Axon of Nebraska has made some statements. They still reserve the right to change their opinion. But there are a good number of senators that have made public statements. Then you go down the list. the ones that introduced him. There's 6 that introduced him. And of that 6, 2 or 3 of them voted against Boyd, just on a numbers count.
You served as Chief Justice of the Alabama Supreme Court. Do you think that Clarence Thomas is the best qualified person to sit on the United States Supreme Court?
Well, I wouldn't think that he's the best qualified. I would say a lot more better, but the question is he qualified? I mean, if you start saying, is he the greatest legal scholar in America? Is he the greatest practitioner? Is he the greatest law professor? I wouldn't, or is he the greatest lawyer in the field of administration? I wouldn't put him in that regard, but I think that my going into this was that he was minimally qualified. And I would agree with the American bar, qualified from a viewpoint of some of the basic elements that they look at. Now you got to go into issues that come up like confirmation, conversion, and you've got to look at how he responds to another question, his ideology, a lot of other factors. But I think just strictly he's shown some scholarship that I think says that he's qualified.
Minimally qualified isn't exactly a great reputation, which that's what you determine.
Well, just like American bar, they have either well qualified or qualified. They make a distinction. But from the viewpoint of qualification, is the legal background, his training, his scholarship, those what you might call craftsmanship tools. I think he's minimally qualified.
Mm-hmm.
We're waiting for the afternoon session of the Senate Committee confirmation hearings to resume. And while we're waiting, we're talking with Democratic Senator Howell Heflin from the great state of Alabama. Senator, since you once were a judge yourself, I'd like to ask you about we've had allusions to it throughout these proceedings about the balance on the court, that the court is now tilting too far to the right, that it's becoming a bit more conservative. And there are those who contend that this doesn't serve the country very well, that you need a more representative court. What's your view about that argument?
Well, you'd always like to have an ideal court that's balanced, that takes into account all various elements. But the election of Reagan for 2 terms, Bush now, and the fact that a number of them have do it, they're going to be people of their persuasion. And that's been true. Sometimes they make mistakes. They think is someone of their persuasion. Eisenhower appointed Brennan. Eisenhower appointed Warren. And it be different from what